Hi, it's Eileen here from Anthony Gold. I'm joined by Beth Holden, who's a solicitor here. We're going to talk about a recent property fraud case that she's won. So Beth, could you tell me a bit about the case and what happened?
Yes, I acted for a claimant who was successful in recovering 100% of the money that he paid to purchase a property in 2012. We sued the solicitors that acted for a fraudulent seller, and we also sued my client's own solicitors for recovery of the money. The reason why we had to bring proceedings against the professionals was because the seller wasn't able to validly and legally pass title to the property to my client. And it's well established that where you have a fraudster signing a transfer deed and money is paid over, you don't have valid completion because the fraudster doesn't actually have title to pass the property.
Okay, so what makes this case unique then?
This is a unique case because it is the first decision by a court to look at the obligations of a seller's solicitor when the seller's solicitor has been innocently caught up in a fraud. It's well established that solicitors or conveyancers hold money on trust for an individual in a land registry or in a typical conveyance transaction. And when the money is passed from the client to their own solicitor onto the seller's solicitor and then off to the seller, that usually produces completion. But as I said, if the seller's a fraudster, then there is no completion and the solicitors have paid the money away in breach of trust. So the solicitors applied for relief from the obligations as trustees to reconstitute the trust, in other words, to pay the money back to my client, because they said that they had done everything that was reasonable and that they should be relieved of their obligation to pay the money back. The purchaser's solicitor's obligations had already been tested in the case of Santander v RA Legal Solicitors, which was at the Court of Appeal last year. But in this case, the court looked at the vendor's solicitor's obligations and it held that there was no difference between a vendor's solicitor and a purchaser's solicitor in terms of the trust obligations and duties. And both firms of solicitors were in fact ordered to pay back the money, and there was an equal contribution between the two of them for that. So it does, for the first time, look at the application of those established trust principles.
Okay, and it would seem that property fraud is on the rise. Should homeowners be worried, or is there anything that they should do to prevent this?
I think that this case is a good lesson in the steps that homeowners should take if they're not actually living at a property, because the land registry offer I think you can have 3 addresses as your address as the proprietor, including the property. So in this case, the real owner of the property had put a second address on the proprietorship register, and it was in fact only when the land registry wrote to that second address on receiving my client's application to be registered as the new owner that the new owner actually even knew what was going on and alerted everybody to the fraud. So for people not living at properties, if there's no mortgage on the property, if the property is vacant, then they really should be taking steps to make sure that they keep their address up to date and that they have address, email and contact details lodged at the land registry.
Okay, and what about conveyancing solicitors then on the other side? I mean, could you tell me, should they be worried or concerned about the result of this case?
Well, I don't think that this case puts any new obligations on conveyancing solicitors or conveyancers. What happened in this case was that the 2 professionals involved in the transaction were trying to get it done very quickly, and they fell into some quite familiar traps when corners are cut and care isn't taken, when speedy transactions are required by a client or both sides of the transaction. So here the fraudster solicitors didn't comply with money laundering regulations. They didn't take any steps to connect their own client with the property that was being sold, because he wasn't actually living at the property and he gave a different address to the solicitors, and it was in fact a different address from even the second address on the proprietorship register, and the property was high value, unmortgaged, and vacant, which are very much red flags for making sure that you carry out proper risk-based due diligence. And on the side of my clients' own solicitors or conveyancers, they hadn't in fact passed on information that they had received when they raised requisitions about the property, which again is something that solicitors are obliged to do, and that's nothing new.
Okay, well Beth, thank you so much for talking to us about that, and I hope you find it useful.